When a rental property goes up for sale in California, everyone has something at stake. The property seller wants to maximize their investment. The tenant, whose home this is, needs to protect their rights and their housing. The home buyer needs to understand exactly what they're inheriting. And the real estate agents, they're the ones who can make this work smoothly for everyone. Or watch it fall apart. I'm Pat Kapowich, and welcome to Housing Market Savvy. Today we're pulling from the Kapowich Vault, an evergreen interview I recorded with two top-notch real estate attorneys, Adam Pedersen and Ashlee Gonzales from Brewer Offord Pedersen in Palo Alto. Their firm has been handling California real estate law for decades. Here's why I'm sharing this in this podcast form. California's tenant protection laws created a framework that affect every party in these transactions. Rent control, just cause evictions, mandatory relocation payments, Civil Code Section 1954 entry requirements, the estoppel certificate. These aren't obstacles. They are the rules of the road. And when everyone understands them, these transactions can actually go smoothly. If you are a property seller, you will learn why planning a full year ahead changes everything and how the right approach can preserve your equity. If you are a tenant, you will discover the leverage you have and why early communication benefits you. If you are a property buyer, you will understand exactly what lease obligations transfer to you and how to evaluate an occupied property. And if you are a real estate professional, Adam and Ashlee walk you through the forms, the disclosures, and the coordination that separates the best agents from those who create problems. This practical guidance straight from attorneys will help all sides navigate this transaction. And here's the interview.
Yeah, we like to say we cover real estate from the ground up. So we've got somebody in the office who has a specialty that will meet their needs.
And we have been down this road together, Ashlee, on selling property when it's tenant occupied.
Yeah, it's huge in this area.
Okay.
There's a limited availability of homes on the market. And in markets like this where there is a shortage of availability, this is one of the main issues that everyone deals with.
And of course, when a tenant, that is their home.
Right.
Right.
And so now when people come to invade it for inspections or showings, it's not a happy time, right? No. Okay, so we got a lot of material. So let's plan ahead. You're a seller and you decide to sell a property that's tenant occupied. What's one of the things that we need to do?
Well, I like to say that you should start thinking about this about a year out. And I say that because that tends to be the duration of most people's residential leases. Right. And so you want to start thinking about what your plan is for selling so that you can coordinate the end of that lease and the end of that tenancy by extension with your planned sale.
Mm-hmm. And we have spoken about that in the past, Ashlee, where it's a good idea to speak with your attorney and your accountant and make sure you have a clean path.
Yeah, we actually had a case recently where a client did an online lease. They were trying to save money. They drafted their own lease and, no fault on them, but it's really, we don't advise that because what happened in that case, they had a tax deadline earlier this year and they drafted the lease that went beyond that. And so the tax deadline required them to either sell the property or move back in before that deadline, and their lease prevented them from doing that. And
Okay, I remember you speaking about that. That is where somebody decides, for instance, they might be on Carmel and find a duplex down there and say, boy, let's buy this. They buy it. And then they go back to Silicon Valley and say, hey, we need to sell this. Yeah. And they don't want to meet with an attorney because that might be an hour or two in fees. And they go online, draft a lease, and then all the clock is ticking on a time frame for the IRS in order to avoid a taxable event.
Right.
Okay. Now, Adam, you have spoken about this. I've seen you speak often about when there is rent control and an ordinance. Can you speak to that issue?
Yeah, that makes it particularly problematic because in most rent control jurisdictions, they also have a statute that they call commonly just cause eviction. And what that means boiled down is that there's usually between 8 and 10 reasons that one of them has to be present in order to remove the tenant from the property.
Well, it's like a spreadsheet.
Exactly, yeah.
Right.
And if you don't fall into one of the categories, you don't have any right as the landlord to evict the tenant. And I think that most people don't necessarily understand that, and they may have an intention or a plan to serve a regular 30 or 60-day notice.
Right.
But in effect, that type of notice does not exist, is not effective in a rent-controlled jurisdiction.
Okay, for an example, real quick, you had spoken about somebody had given it a generous offer to the tenant to move out early.
Right.
And the owner, seller, landlord thought it was a reasonable offer, but it turned out to sound like a demand.
Right. That's correct. And so, again, with those jurisdictions that have that just cause eviction, there's often a relocation payment that's mandatory, that if the owner intends to move in or to sell the property, there's a payment that's required by law, and it can range from $10,000 to $12,000 per adult tenant. So it can be substantial.
Right.
And in the case that you were referring to, they had made an offer that they felt was generous, but was not as much as the $10,000 to $12,000 apiece that the law would have given them. So it made the offers look like coercion, like the landlords were trying to make the tenants accept less than what they were objectively entitled to. And so it can be a problem.
So that's what you're speaking about, planning in advance. Okay. Now, for instance, in all fairness, if somebody is vacationing or visiting friends back east and they see something wonderful and they go into the office and just buy it, and they have to come back here and work backwards. So as soon as they come back to Silicon Valley or the Bay Area, they should meet with their accountant.
Yeah, that's very important. A lot of people in certain markets, they do 1031 exchanges and that type of purchase where it's contingent on either the sale or purchase of another property. And we don't know the tax law on that. It's just too much for us to be experts on. Real estate enough is broad in and of itself. So we always recommend our clients to go and speak to either a CPA or a tax attorney to really nail down those amounts.
Okay, good point, because we have spoken about this in the past. We've worked together in the past on properties, and there's a situation where you might let the tenant's lease expire and not renew the lease.
Right.
And in that case, you could give them 2 or 3 or 4, 6 months notice. Say, I won't be renewing the lease, so perhaps you should start moving.
That's the cleanest way to do it, for sure, and it just requires a little bit of planning. And for example, the situation Ashlee was describing earlier, I think that the landlords in good faith were just trying to do the right thing, but had they known to plan in advance, a year in advance, they could have, instead of doing a year lease, for example, done a 10-month lease or otherwise, and that would have given them plenty of time to market the property.
Okay, Ashlee mentioned a good point about the 1031. That's a tax code.
Yeah.
Right, that's a tax code. So, and you had mentioned about, I know for a licensee, a real estate licensee, we cannot just give legal advice or tax advice. So we are trained to seek the accountant's advice and legal advice. And you basically do the same thing with the brokerage or the accountant?
Yeah, I recommend for agents, sellers, basically anyone. We do as a firm have vendors in your pocket that you can call and rely on when you can't solve a problem yourself. Either if you're an agent or a seller, go out and seek the help. Don't always rely on your own knowledge, because you could really back yourself into a corner.
Right, and your firm, of course, defends a lot of real estate agents.
Yes.
And they start giving advice at the kitchen table at 9 o'clock at night, and they move forward, list the property, get it under contract, and we have a problem, several problems.
Yeah, they can't help it. Some agents blend the line between their duty and what they're allowed to do, and I don't fault them for that, because I think they're trying to go the extra mile. But you have to really know your limits and rely on the experts that do that for a living. Right,
so that's a good lesson for the licensees. You don't have to be a know-it-all.
No.
Right? Just concentrate on the brokerage. Now, there's a good point. We've spoken about this in the past, and of course, as when I was a young realtor, I understood this as well, real estate agent, is that if it's tenant-occupied, it's difficult to show.
Right.
You can't fix the property up, things like that. And you have mentioned in the past there's a number in terms of the percentage that it may hit.
We've been talking about that just because of the case we just had where our clients missed out on a larger sale price, and experts say it could be anywhere from 20 to 30% higher if you sell without a tenant, and to me that is substantial.
Right, so that's a good reason to, one, have the tenant relocate,
Right.
give them a good incentive to do that, so that the owner of the property, with the help of the licensee, can start fixing it up.
Right.
And it's especially true in rent-controlled jurisdictions, because there, whether the property is going to go to an investor buyer or an end user of the property, if you have a tenant that's in there who can only be removed for a handful of reasons and whose rent is constrained by law, that obviously has a great impact on the value of the property in the market.
I see.
Right.
Okay, advice for the seller's agent. Now, most residential agents, now let's be clear, we have commercial real estate and residential real estate. And oftentimes, a homeowner who has a neighborhood realtor or a real estate agent, and he or she might own a duplex and a fourplex.
Right.
Then rather than getting a commercial agent who specializes in apartment buildings, they can have Bob or Sally who does homes. And so now we have an agent that does a tenant-occupied property every 7 years.
Yeah, there's some disconnect there, and a lot of agents are fearful of helping a seller sell a property with a tenant inside, and they don't have to be. There's actually a form that the California Association of Realtors created for agents that's called a notice of sale and entry. And that's one of the first steps we recommend for our agents that we represent, is serve that on the tenant. And what that does is it outlines the complicated law on the issue of entry with a tenant. And it tells the tenant that they have, for 120 days, the seller or their agent or buyers, whoever, can enter the property with 24 hours oral notice. Obviously, there's some restrictions to that. You have to be reasonable.
Sure.
And we can talk about that later, but it's powerful, and agents really shouldn't fear that element of their work.
Now, Adam, I have often spoken about having inspections from the top down, the chimney inspection, roof inspector, home inspector, which is heating, plumbing, electrical, and then the termite inspector. Now, for the tenant, that is their home. Typically, if the property was vacant, we can schedule an inspection every day of the week.
Right.
But when it's tenant occupied, you want to stagger it every 45 minutes.
Yeah, we always recommend to both our sellers and our sellers' agents that they try to consolidate as much as possible their visits to the property, be it with potential buyers or inspectors or otherwise.
Right.
And to go back to what Ashlee was saying, a good opportunity to do that is when the agent is delivering this form that she's described, the notice of sale and entry. That's a good opportunity to start talking with the tenant about what scheduling can look like, and maybe even reserving a specific number of days in the future for open houses and for inspections, all of which are allowable under the law. The landlord is allowed to do all of these things. But again, because of what you said, Pat, the personal relationship the tenant has with the property, it's something to be, that needs to be taken care of.
Yes, because it usually doesn't start out well. The tenant doesn't want to leave or move, be uprooted, and now they have these strangers coming to their home and on their doorstep.
Yeah, rightfully so. And they should, I think people fear change, but if you touch it at first with mindfulness and respect, I think it goes a long way.
Right, and this is for the licensee representing the seller, seller's agent.
Right.
Really will get farther with honey than they do with vinegar, right?
Absolutely.
Okay, because also the tenant has to move everything out of the closet to make sure the access to the crawl space is available. And oftentimes the garage is full of belongings.
Right.
So really need to work as a team to do the proper inspections.
Right.
Okay. Now, in terms of the disclosures, oftentimes the seller will say, well, I haven't been there. I haven't been there for 2 years. And now this agent representing the seller is there twice a week now. What happens with disclosures?
So one of the most important disclosures that a seller has to make, and that a seller's agent by extension has to assist their seller with, is what we call a tenant estoppel. Quite often when property is being sold as a rental, especially if it's being sold for investment purposes, which is common, a lot of the value is derived from the rents collected and what that looks like financially for the potential buyer. So this tenant estoppel is a one-page form. It's promulgated by the California Association of Realtors, very commonly used, and it allows the tenant the opportunity for the tenant to fill out the understanding of the lease agreement. So how much they're actually paying in rent, how long they've actually been there, and they put all that down and then they sign it. So the tenant themselves owns it.
Oh,
And
okay.
that's important because it's an objective source to provide to the listing agent and the seller.
Right.
So that's a very brief form, right? It's just you're asking. The key word is stop, right? So that the tenant will write down their understanding that it's XYZ per month, and they have a security deposit of XYZ and cleaning deposit.
Correct.
And then they sign and date it, and then later they are stopped from coming back and say, "Oh, I was mistaken."
That's correct.
Right.
Okay.
Yeah, we talked about it before, and I said that in some cases, the court actually held the tenant to what they put in the estoppel certificate, and because in certain markets, some property owners have owned the property forever and they haven't updated the lease in some time, so no one really knows what the terms of the lease are.
Right. It's lost.
Right. It could be. I've seen leases that look like a parchment, an old England, style parchment.
Yeah.
And we have to update it for them. But long story short, I think the estoppel certificate will clarify the situation for everyone.
Okay. Now, in terms,
I would say one of the most important parts about that too is that it comes from the tenant and from the perspective of the licensee, the seller's agent. The seller's agent may not have full information about the property, right? And so one case I seen before was multifamily property, small apartment complex was being marketed and with a certain level of rent. However, unbeknownst to the listing agent, that rent included Section 8 money as well as a cash supplement, if you want to call it that the landlord was charging on top.
Right.
So that information was passed on then to the buyer who made a purchase offer based on that information. And then it came out after the close of the sale that in fact the rent that was legitimately being charged, the Section 8 rent, was being supplemented by these otherwise not allowable cash payments. And so the new landlord could not collect those, legally speaking, from the tenants who brought that to his attention when he took ownership of the property. And so had he gone to the tenants vis-a-vis the estoppel during the escrow, that would have put this information on the table early on, and the buyer could have made a decision to either go or stay based on that information.
Okay, that's an excellent point. And that's something in terms of when the seller hires an agent, the seller's agent's gathering information. The seller agent needs to find out what are the rents right now, period. End of story.
Right.
Yep.
It's very easy to do. One simple change in that case would have saved hundreds of thousands of dollars.
Now, also, if the seller's agent is there and notices barking dogs next door or some loud music next door, that's part of the disclosure that the agent will have to make, correct?
Absolutely. Yeah, absolutely. We would call those sometimes environmental conditions. And so anything that the listing agent or the seller's agent notices about the area needs to go on their disclosure form.
And really, I see this all the time as an agent. Everything looks wonderful, it's very peaceful, and I walk in the backyard, and next door neighbor dogs has 3 or 4 dogs that just want to climb over the fence. They're just, all 3 are barking.
Yep.
Okay. Now, in terms of, let's say, now for the tenants that are listening or watching, if they are now all of a sudden, they're always on pins and needles in the Bay Area.
Sure.
Am I going to be able to stay here? Or are the sellers going to be selling soon? So what rights do the tenants have?
Well, first and foremost, as a general rule, and this is statewide and true across the nation, is that the new buyer takes the property subject to the tenant's rights.
Right.
So if you're 6 months into a 1-year lease, that lease is going to be in effect after the sale.
Right.
So from the buyer's perspective, you should know that. And from the tenant's perspective, you can take some level of solace in the fact that you've got your lease rights, and there's something that if they're going to be altered or changed, that you've got the power to negotiate those rights because you've got a lease contract that secures your rights.
Okay, Ashlee, in the Bay Area, a deposit might be 2 or 3 times the rent.
Yeah, it arguably could be, and just another right that they have, I would say that a lot of tenants aren't aware of, is you have leverage as a tenant. You know, what we talked about earlier, where a seller can get more money, use that. More than likely, they're going to pay you less than they would get if they sold the property without you in there. So you actually have the upper hand, and a lot of tenants don't think that, and they should.
See.
Yeah, and seeking legal advice would tell you that, because we would say, hey, this guy is better off selling the property without you. Let's start a conversation, and that needs to happen early.
Okay. Now, the conversation we're speaking about is I will leave early
Yep.
if I would receive 4, 5, 7 months rent.
Right.
Right.
Yeah. It could be a substantial amount. You'd be surprised what people pay in a competitive market.
Now, during the Great Recession, we call that cash for keys. The
Right.
banks started offering cash for keys to get the people out of the building.
Right. We still use the same term to describe those agreements, cash for keys.
Yeah.
And it's literally because the way they're orchestrated, you get your money, your cash payment as the tenant when you deliver the keys to the landlord. And so that's why we call it cash for keys. And it is very powerful, especially in rent-controlled jurisdictions where the tenant can leverage their position oftentimes substantially because the impact on value is so high. We've seen cases where if the tenant's able to catch, especially the landlord, in a misstep, buyouts can reach beyond $50,000 for a single tenant.
Yeah.
Wow.
Yeah.
Okay. So let's start from the beginning here. They get notice that the sellers are selling.
Right.
When they get over the shock, the first person they might not see the property manager, who they might have a great relationship with. It's going to be the seller's agent.
Some random guy off, as far as they know, off the street that is in a suit trying to make a good impression, but to them, it's a guy that's selling their living space.
Right.
And so it could be intrusive, but you should know as a tenant, although you do have a lot of rights, as we talked about, you have to comply with that notice, and you have to comply with state law. And so while the agent may not seem to you as a tenant they have your best interests, they really do, and they're just trying to be courteous to you with that notice of sale and entry form.
Now, they still require 24-hour notice, right? Regardless.
Yes.
Still 24-hour notice.
Yeah, no matter what. If for some reason agent doesn't know about the form or that it just slips, Civil Code Section 1954 is the code section that outlines the procedure for entry, and you don't have to serve the form. But in that code section, the powerful part why we recommend the form is it requires written notice. So there's a difference there.
Oh.
You're still permitted to enter if you're a landlord or their agent, but it requires an extra step.
Wow.
Yeah.
Okay, and by the way, the seller's agent could look up the civil code.
Oh, yeah.
Now, moving along here, real quick, I want to mention that both landlord-tenant, we have tenant-landlord agencies throughout the Bay Area that are there to help each other.
Right.
Right? Okay, now, build a relationship with the buyer.
Yeah.
If there is a buyer and they're home, oftentimes they're at work and they don't see what's happening at the house, but if they get a chance to meet the new buyer.
Yeah.
You have often mentioned about building a rapport with the new buyer.
Yeah, ultimately that's going to be your landlord if they do plan on keeping you, or if they have to keep you because of your lease. And there's no reason why you can't start that relationship out on the right foot.
Okay, let's one more time. We've talked about it. They should seek legal advice. Do they need legal advice for the estoppel certificate? That's, again, the form that they need to fill out. What is your rent? What is your lease terms? How much of a deposit? What is your understanding?
I would say that I would recommend they get legal advice in completing that form. If for no other reason, then that's an opportunity for them to go in and sort of have a legal health checkup on the transaction writ large. Have someone look over it all, say, hey, has your landlord complied with the law? Is there an ordinance that may benefit you? Are you willing to consider a buyout? Right. Has there been discussion of that? All of that conversation can probably be had in about an hour's time. So for the price that you pay in legal fees, it's enormously worthwhile to do. Right. And as far as the estoppel goes, really, the tenant's only obligation is to fill it out accurately and truthfully. And so just know that, as Ashlee said before, case law says you're going to be held to that. So, the law expects that you do it truthfully. And certainly if anyone is putting pressure on you to make any inaccurate statements in that estoppel, huge red flag, call an attorney right away.
There you
Big
go.
time.
Okay. Now, in terms of working with the real estate community of the buyer's agents, you have the seller agents, and traditionally we would, a buyer's agent will call the home and leave a message. Hi, this is Pat with Kapowich Real Estate. I want to show your home Tuesday at 5. I'll lock up and leave a business card. If that's a problem, please call me back.
Yeah.
A little different when we have tenants, right?
Big difference in my opinion. You had mentioned before that sometimes buyer agents, they call and they don't hear back and they just show up. And that's a problem when you have a tenant there. It can be trespass. It's a violation of the code. So we recommend having the seller's agent be the middleman and coordinate those showings and coordinate actually going to the property. It prevents all of that.
Okay, because oftentimes we've seen the remaining minute here is where it starts out, everybody's getting along and there's a bad showing and now there's no more access.
Yeah.
Okay, we have spoken about random agents coming to the door. So this is, Adam, where the agents, the seller's agent could put in a listing, do not go to the property unattended.
Yes.
Absolutely.
Call the listing agent first.
Yep.
We need to make an appointment and do everything properly.
It's very important.
And not only does that protect yourself and protect your seller, but it's a service point for the licensee. It's something that they can bring to their listing presentation and say, hey, this is what we do. And it distinguishes them, and it's important for both, I think, legal and business reasons.
I agree.
Okay. Great. Thanks again for coming out.
Thank you.
That was attorneys Adam Pedersen and Ashlee Gonzales from Brewer, Offord, and Pedersen. If you need legal help with tenant-occupied property, whether you're the property provider, the tenant, or the real estate agent caught in the middle, their number is area code 650-327-2900. You can always find them at brewerfirm.com. As always, this is educational content, not legal advice. Laws do change. Your situation is unique. Consult with a qualified attorney and tax professional before making decisions. If you found this valuable, subscribe to Housing Market Savvy wherever you listen to podcasts, and check out my YouTube channels for video versions of this channel. If you found this valuable, subscribe to Housing Market Savvy wherever you listen to podcasts, and check out my YouTube channel for the video version of this interview with timestamps so you can jump directly to the topics that matter most to you. I'm Pat Kapowich, SiliconValleyBroker.com, your consumer protection advocate. Until the next time, take care.